There's a recent court decision in a bankruptcy court in Illinois that could bring some relief to restaurants who have been unable to make lease payments during the COVID-19 shutdowns. So in Illinois, the governor issued an order in the middle of March requiring all restaurants to close for indoor consumption. In other words, they couldn't have people come into their restaurants, sit down and dine. They could continue takeout, but that was it. Now, Hilt's restaurant suffered financially because of this, and the order eventually drove the restaurant into bankruptcy. During the months before the bankruptcy, during the order, the restaurant did not make its lease payments. Now, in bankruptcy, during the proceedings, the landlord filed a motion asking the court to order the restaurant to pay the delinquent rent payments. Now, the restaurant, Hilt's, argued that the force majeure clause in their contract essentially excused the restaurant from making the payments. So force majeure means a greater force, and it's a common clause in most contracts. And essentially it states, if there is some greater force that prevents a party from fulfilling its obligations under a contract, then that party is excused from those obligations. So in other words, something like a government order or a law that would prevent one party from fulfilling the terms of its contract, essentially the force majeure clause excludes or excuses the party from fulfilling those terms or obligations. So in this instance, the lease agreement between the restaurant and the landlord contained the following force majeure clause. It says, landlord and tenant shall each be excused from performing its obligations or undertakings provided in this lease if such actions are prevented or delayed, retarded or hindered by laws, governmental actions or inactions, or orders of government. Now, the bankruptcy court agreed with the restaurant and said that this clause excused the restaurant from making the full rent payments for the months that the order was enforced. However, the court said because the restaurant could still operate through its takeout business, and because the takeout business generated about 25% of the restaurant's annual revenue, the restaurant still needed to pay 25% of its rent for those months. And one other side note, the landlord argued that the restaurant could have applied for a government loan, a PPP loan, Payment Protection Program loan. And the court rejected that and said that the tenant or the restaurant was not obligated to borrow money to pay the lease because there was nothing in the lease that required the restaurant to do that. Okay, so this offers at least some good news if a restaurant has been driven into bankruptcy, or maybe even other businesses who have similar clauses in their lease agreement. It should be noted that the court here applied Illinois law. Even though it's a federal court, it applied Illinois law. So laws will differ from state to state, and this may not apply in every state as favorably as it did to the restaurant here. If you need legal representation or if you have questions, please contact me, send me a message, send me an email, and I'd be happy to help you.